10 seconds, 5 seconds. Start. In that case, the only point for consideration before the Supreme Court was whether prosecution for offences punishable under Section 276C and Section 227 of the Act and under Sections 193 and 196 of IPC instituted by the Department while the reassessment proceedings under the Act are pending are liable to be quashed on the ground that they were not maintainable. It was held that pendency of such proceedings cannot act as a bar. In that context, in para 6, it was further observed at page 1200 of LR tax. It may be that in an appropriate case, the criminal court may adjourn or postpone the hearing of a criminal case in exercise of its discretionary power under section 309 of the code if the disposal of any proceedings under the act which was a bearing on the proceedings before it is imminent so that it may take into consideration the order to be passed therein. Even here, the discretion should be exercised judicially and in such a way as not to frustrate the object of the criminal proceedings. There is no rigid view which makes it necessary for a criminal court to adjourn or postpone the hearing of a case before it indefinitely or for an unduly long period only because some proceedings which may have some bearing on it is pending else. If the order of concealment and penalties, there is no concealment in the eyes of law and therefore the prosecution cannot be proceeded with by the complainant and further proceedings will be illegal and without jurisdiction. The Assistant Commissioner of Income Tax cannot proceed with the prosecution even after the order of concealment has been set aside by the tribunal. When the tribunal has set aside the levy of penalty, the criminal proceedings against the appellants cannot survive for further consideration. In our view, the High Court has taken the view that the charges have been framed and the matter is in the stage of further cross-examination and therefore the prosecution may proceed with the trial. In our opinion, the view taken by the learned magistrate and the High Court is fallacious. In our view, if the trial is allowed to proceed further after the order of the tribunal and the consequent cancellation of penalty, it will be an ideal and empty formality to require the appellants to have the order of tribunal exhibited as a defense document in as much as the passing of the order as aforementioned is unsustainable and unquestionable. In the present case also, perusal of the order of ITAT dated 13th December 1991 clearly reveals that it was held that in order to find out the bona fides of the SSC's claim argued before ITAT, it was very necessary to know the correct state of affairs regarding the three statements recorded at the subsequent states subsequent to the assessment proceedings. It was also observed that without handwriting expert's report, when the accountant refused to admit certain portions of his statement made in the accounts book, it was difficult to arrive at a conclusion that the SSCs had mens rea to conceal the particulars of income of not.